Hi, this is Rakesh Kapoor. I welcome you to judicialcompetitiontimes.com, India's leading website that offers online coaching classrooms for the preparation of all state judicial service examinations. You are watching video number 2. The subject is Indian Penal Code. In video number 1, we have already discussed the definition of a crime and the concept of mens rea. In this video, we will discuss about the stages of crime. There are basically the 4 stages of crime. The first is the mens rea, or the intention or the motive to commit the crime. The second stage is the preparation or arranging the means to commit a crime. The third stage is to make an attempt to commit a crime, and if suppose that attempt is successful, the fourth stage is of the completion of that crime. So let us discuss these various 4 stages one by one. Let me start with the first stage, that is gathering the intention, motive, or having a mens rea to commit the crime. For that purpose, let us first of all try to understand what the intention is. Criminal intention simply means the purpose or a design of doing an act which is forbidden by the criminal law without just or excuse. The intention of the accused to produce a particular consequences shows his intention to do that act. Now this intention, mens rea, or the motive of any person, it is gathered by his conduct. Basically, it is the conduct or the circumstances which shows that whether a person has a motive or intention, or whether he possesses any mens rea relating to that act or not. Now, as far as the general principle of the intention is concerned, every sane person is presumed to intend the necessary or the natural and probable consequences of his act. But this presumption, however, is not conclusive in nature, nor alone it can be sufficient to justify a conviction, and should be supplemented by the other testimonies also. Therefore, an accused must be judged to have the intention that is indicated by his proved act. The second stage is the preparation to commit the crime. Here, the preparation means arranging a means or devising a means to commit a crime. So whenever any person want to commit any crime, he has to make an arrangement. He has to collect certain weapon of offense, or say, suppose he have to collect the money from somewhere so that he can commit the crime. So for that purpose, he has to make an arrangement and he has to devise the means for that purpose. For example, is suppose one person wants to murder someone. For that purpose, he want to shoot someone. In that case, he has to purchase a gun from the market. So if suppose he is purchasing a gun from the market, what he is doing? He is making a preparation to commit that offense. Okay. Now the general principle is that the preparation is not an offense. If suppose some preparation is done relating to some offense, it is not an offense, because a person may change his mind also. He may think that he don't want to commit the crime. So for that purpose, the law has made a provision. The general principle is that the preparation of an offense is not an offense, but we have certain exceptions in this regard. Now what are these? The first exception is section number 122, which make the preparation for collecting the arms etc. with intention of waging a war against the government of India is punishable. Similarly, making a preparation for collecting or making the any depreciation or like depredation on the territories of any power which is in alliance with Indian government, right? It is also an offense under section 126. Similarly, if suppose anybody is making any preparation to commit an offense under section 399 of IPC, it is also an offense under IPC. According to section 233 and section 234, making a preparation for making a or selling the instrument for counterfeiting a coin or Indian coins, this has also made punishable. Now let us discuss the third stage, attempt to commit the crime. The attempt is said to be done when a person does any act such that he does not possess any control over such act. That is, he cannot control the consequences of such act after doing such act. For example, when any person fires a gun, as soon as he pulls off the trigger, the consequences no more remain under his control. So in that case, we say that he have made an attempt. The inflicting of the injury is not necessary in the case of attempt to commit any offense. That is, it is not necessary that the consequences shall ensue as it was intended by the doer of that act. It is mere the fate of the victim whether some harm, etc., has been caused to him or not. Let us discuss one case law in this regard. Sudhir Kumar Mukherjee vs. State of West Bengal, 1973 Supreme Court 2655. In this case, the apex court has held that a person commits the offense or attempt to commit a particular offense when number 1, when he intended to commit that particular offense, meaning thereby he must have an mens rea, or he must have a guilty mind, or he must have some intention to commit that offense, and he having made a preparation with the intention to commit that offense, he does an act towards its commission. Such an act need not be penultimate act towards the commission of that offense, but it must be an act during the course of committing that offense. For example, suppose A wants to commit the murder. Now what he do? First of all, he gathers the intention for that. Then he makes a preparation, that is, he purchases a gun. Now what he do? He loads it. Now up till this stage, he is not guilty of any offense because he has not made any attempt. So until he makes a fire, he is not guilty of any offense. But as soon as he fires the gun, he would be guilty of an offense to commit a murder. Let us discuss the provision for an attempt to any offense. This specific provision relating to attempt to commit a crime, it is provided in section number 511. There are numerous offenses which are made punishable in IPC, but the specific provision for attempt for all these offenses are not provided. So the cases where the IPC does not provide a specific provision for attempt to commit the crime, that act must be covered under section 511. Say for example, suppose the act of attempt to commit the theft, it is not provided in IPC. So here this act would be governed under section 511 of IPC. In this video, we are not going to discuss in elaborate crime, section 511 of crime. So when any attempt as intended by the doer, it got successful, then we say that an offense has been committed. So that was all about the various stages of this crime that we have discussed in this video. So keep watching our videos on Indian Penal Code and have a nice day.